Good morning, everyone. I'm Matt Dana, and I have with me today Trevor Whiting. Hi, Trevor.
Good morning, Matt.
Trevor and I have been together for over 15 years, and we're partners of Dana Whiting Law. We're the founding partners.
Founding partners.
Wow,
we're
still
the
together.
OGs is what they call it, yeah.
So, Trevor, today we're going to switch gears. I mean, we've made a lot of videos together on the United States estate tax, gift tax, and generation skipping. And Trevor, I think it's fair to say in all humility, we are experts in the federal estate taxes, and we call those transfer taxes. And we know that when somebody in the United States has wealth and they die, there's an estate tax we have to pay. We know that that person that has wealth and they're trying to avoid the estate tax, they've got to be careful about the gift tax. And then we also know that if they're putting assets in one of our green boxes, that's a multi-generational green box, they have to worry about the generation skipping transfer tax. And so far, we've done a lot of speaking and writing on those topics. Today, Trevor, we're going to talk about a topic that you and I love. And Trevor and I both went to NYU and we received our LLMs, which is a master's degree in taxation from NYU. And we both took a class on international estate planning. And Trevor, I have to say, I think that international estate planning was one of the most interesting classes that I ever took. I don't know if you feel that way.
Yeah, it's certainly a concept that you don't address with every client situation.
Yeah.
But when you get into it, I agree. It's one of the most interesting topics that we get into.
Yeah, and just within the last few months, we've picked up some good clients from New Zealand and some clients from Mexico, and so I know there's people out there searching these topics. And in these cases that we're picking up, these are cases where the person that generated the wealth, they generated that wealth in another country. And I'll just say New Zealand because it's top of mind. They generated the wealth over there. That person is not a U.S. citizen or a U.S. resident. And I think, Trevor, what's the technical for that? A tax person?
A U.S. person.
They're not a U.S. person.
Not a U.S. person.
A U.S. person would be either they're a citizen of the United States or they're a resident of the United States.
Or a green card holder.
Yeah. Okay. So they're not a U.S. person, meaning there's no hook to them to the United States. But they could have a lot of connections with the United States. In this case that we're working on, they actually have a spouse that's a U.S. citizen. They have children that aren't U.S. citizens. And so, the real question is, as they get more and more ties with the United States, they really worry about that this wealth that they've created somewhere else is going to be brought into the United States estate tax system. So can you tell me where are some kind of pitfalls or areas that they really need to kind of pay attention to kind of keep this wealth from coming into the United States and under our system?
Yeah, and one of the big areas is these individuals that are accumulating this wealth outside the United States, they frequently start to think, I'd like to invest in the United States as well.
Yeah.
I want to buy real estate or stocks in U.S. companies and things like that. And now as they, like you're saying, as they continue to have these more and more ties to the United States and have assets here and have other, maybe family members or other connections to the United States, maybe they buy a place, a temporary residence here, then they start have to worrying about if they pass away, these assets that are US Situs assets would be included in the United States estate tax, and their heirs would have to pay tax on these, and so if we get ahead of it and get in front of it, maybe there's structures that we can set up and put in place so that now they can invest in assets in the United States and yet have those assets exempt from the U.S. estate tax.
All right, let's take your first hypothetical. This person just wants, and let's just say they have no connection with the United States, husband and wife, kids, everybody's in New Zealand, but they want to invest in the United States. And are the assets that they invest in the United States, are they going to be subject to the United States estate tax?
That's a little bit of a tricky question, and it depends. But for example, real estate in the United States, that's the easiest one. Yes, if it's United States real estate, it's going to be subject to the estate tax.
What's the fancy word they use? US Situs.
US Situs Property.
So something that's located in the United States, even though they've never come to the United States, they've never stepped foot in the United States, but they own assets here in the United States, if it's a situs. So real estate, what about U.S. stocks and bonds?
Yes, in general, a stock in a U.S. corporation is going to be counted as U.S. Situs Property, and so there's, again, structures that potentially you could use to keep it so that it's not counted as U.S. Situs Property.
Yeah, and what would be an example of that type of a structure? If
an LLC or a partnership, yeah. But then
does that have to be a foreign LLC or a foreign partnership, or can they create a U.S. LLC and a U.S. partnership that's owned 100% by a non-tax person?
Yeah, in general, they can create a U.S. entity, but the question is now going to become, we're switching from estate and gift tax to income tax.
Yes.
And whether, that's going to be the right income tax structure for that person to own a U.S. LLC or a U.S. Partnership or something like that. So there's a lot of interweaving and a lot of issues that we got to get into as we get into these types of cases.
And keep the topic right now on the estate tax. So the rule is, even though they haven't stepped foot in here, if it's a U.S. Situs asset, they'll pay estate taxes. Do they get the benefit of the $13 million exemption?
They don't, unless there's some sort of treaty between the U.S. and the country their residents
There are some countries that might have a treaty that says if you invest in the United States, we'll give you an estate tax exemption.
That's right.
Absent a treaty, do they get any exemption at all? I think it's
they do. It's real small, a couple $100,000, something like that.
Yeah, and there again, if their spouse isn't a U.S. Citizen, they're not going to get the marital deduction and some of those things. So
right.
I think there's a lot of foreign people that are buying real estate here in the United States that don't really understand that this could be subject to estate tax. I mean, we could get into, how's the IRS going to find it, and how's the IRS going to enforce it, and some of these things, but the issue is they're creating a liability there.
That's right.
Now, here's a topic too. Now, we also know that if you are a U.S. person, you're either a citizen or a resident or a green card, and you're running the risk that the United States is going to tax worldwide wealth, right?
Right.
Now there's your problem. The United States says we don't care whether those assets are in New Zealand or China or wherever. On an estate tax, if you're a U.S. person, we're going to tax that worldwide wealth. So I got to be real careful about that. So on an estate tax, what's the test of how often can they come over here? Yeah. And without coming into this, you're a resident and we're going to do worldwide wealth.
Yeah, on the estate tax, it's a little bit tricky, but the definition.
Well, and let's talk about. I know it's tricky, so I want to talk about the for income tax purposes. It's a little bit easier to explain because it's a bright line test.
Right.
But you're telling me that the test of whether you're a resident of the United States, the test is different for income tax purposes than estate tax purposes.
That's right. So there's multiple tests, and the income tax test is a little bit more bright line, and it's purely based on, there's a substantial presence test is what the IRS calls it, and it's based on the number of days that you're here in the United States.
Get real slobbery here for me.
We'll get real slobbery.
So tell me just roughly speaking, how does this test work? How many days can I be in the United States before I'm substantially present and I'm now a resident?
There's a 183-day test, but how they measure the 183 days is they say we take a look at the current year's, how many days have you...
I came over here 100 days this year.
100 days this year, and then we also add, what is it, 1/3 of the days that you were in the state in the
prior year
in the United States the prior year, and 1/6 of the days that you were in the United States.
You gotta love
year
the
before
IRS.
that.
Are you kidding me? All right. So how many days were you here this year? Add those. 1/3 of the days last year. Add those. 1/6 of the days for the prior year. Add those. And if they violate 183. I'm done.
Yeah, then worldwide income, all of your income from everywhere is subject to the United States income tax.
Yeah, so Trevor, somebody told me mathematically, if you spend more than 122 days a year year in and year out, you'll violate that rule.
Right. So if somebody's here, 5 months every year, and they think, well, I'm here less than half of the year. They're here, more than 122 days. That mathematical formula says that they're going to be.
You wonder how many people are violating that and don't realize, right? And there again, I don't want to get into how does the IRS find, but we do know with computers now and internet and some of these transparency acts and stuff, they're getting more and more detailed of who owns what and where, right?
Sure.
So all right, so that's the test for income tax. It's bright line, you can calculate. What about for estate tax? Different rule.
For estate tax, they say you're a U.S. person if the U.S. is your domicile, and the domicile is defined as your place of residence with no intent to remove therefrom, is how the code
No
said.
intent. It's up here.
Yep.
Did I have the intent to jump off that bridge?
That's right. So if the person can say, I have a home in the United States and I spend a lot of time there, it doesn't, we're not counting days.
I spent 360 days here.
But all of my family's in New Zealand. I always intend to go back to New Zealand.
My mom and dad
I want to
live
die
there.
in New
I've
Zealand.
got burial plots there.
Yep.
My intent.
And
And there are ways as lawyers we can document what their intent is, right?
That's right.
Buy your funeral plots there and maintain a house there and pay your taxes there.
But if they have the intent to go back to New Zealand,
Sweet home New Zealand.
they're
sing
not a
the
U.S.
song.
person,
Right.
and they don't get the benefits of the United States, that $13 million exemption.
Yeah.
But their worldwide assets are not subject to the estate tax either. Just their U.S. assets.
This is good stuff.
good
isn't it?
stuff.
Is there anything else you want to see on the international tax scene before we leave this talk? We got to be careful from the income tax.
Yeah.
We got to be careful from the estate tax. Sometimes those could compete.
They compete, and it's a balancing act. But it's an interesting topic to discuss, and we like bringing it up with all kinds of different clients.
Yeah, and from an income tax standpoint, we want to get it here. But one of the interesting things at NYU is how do you prorate income, where they have manufacturing plants here and here and here and here, and how do those countries prorate it? That's a whole nother story.
Whole nother topic.
Well, thanks for explaining that to me.
You're welcome.
All right.